Chapter 4, Medical, Legal, and Ethical Issues, is going to be extremely important for you guys to understand moving forward. The field of EMS opens up a substantial amount of liability for malpractice or negligence type claims. By understanding the medical and legal requirements of the job, it's going to protect you from potential fallout based on lawsuits or disciplinary action in the future. So I suggest that you pay close attention to this and that you review this material several times over because this is extremely, extremely important. So beginning with scope of practice. Scope of practice is, think of it as your toolbox. It is all of the tools that are contained within your toolbox, everything you've been trained to do. You cannot operate outside of your scope of practice, meaning that if you have not been trained or authorized to perform a certain task, procedure, etc., you're not allowed to do it. For instance, as a paramedic, I am trained to start IVs and administer IV medications. As an EMT, you are not. If you were to start an IV and administer a medication, you would be operating outside of your scope of practice. Once that occurs, you open yourself up to substantial legal liabilities. Um, your scope of practice is defined on several different fronts. First of all, we have the national curriculum that says for EMT, here are all of the different uh, skills, requirements, knowledge, tests, all that stuff that you have to be able to demonstrate. The state of Illinois then comes in and says, okay, but in addition to all that, we also expect our EMTs to be taught, X, Y, and Z. So you have an expanded scope through the state of Illinois. From there, though, once you get licensed into a specific state, such as Illinois, you are bound by the requirements of the EMS system. So this class is taught to the national standards. We also teach the Illinois expanded curriculum. Once you get licensed in Illinois, you have to become associated or affiliated with a EMS agency. Once that occurs, you are restricted by what the medical director and the subsequent protocols will allow you to do. So even though you are taught to perform a skill and you are allowed to do the skill within the general scope of practice of an EMT, the individual EMS system may pull back on that and limit you in what you can do. So you need to know exactly what the EMS system allows, and you have to operate within those parameters. So scope of practice being everything you can do, standard of care kind of sets the bare minimum of what you must do. The standard of care says that, what is the level of care that a similar EMT with similar training and similar circumstances would provide. And if that sounds very subjective to you, it is. Uh, to argue that somebody violated or failed to meet the standard of care is not an easy argument to make. However, it certainly can be done, and we want to make sure that we're always meeting those minimum requirements. And I know it may sound silly because you're thinking, well, why in the world would I not make or meet the minimum requirements for standard of care? Well, there's times that we could miss something, that we could do something wrong. So even though we tried, if we do it incorrectly, we would fail to meet the standard of care. For instance, let's say that our patient has chest pain, and as a result, it's indicated that we administer nitroglycerin. If I administer the nitroglycerin and everything works as planned, perfect, no problem at all. That would be the minimum standard of care. Patient with chest pain should receive nitroglycerin. However, if I administer nitroglycerin and then I give another one, and I give another one, and I give another one, and I overdose the patient on those nitros, and their blood pressure drops substantially, well, based on those errors, that could be construed to mean that I failed to meet the standard of care. So not only is standard of care the bare minimum, but it also adheres to a level of competency as well. The same thing could be used in the example of administering nitroglycerin to a male patient who uses erectile dysfunction medications, any type of erectile enhancements. If I forget to ask and I administer that medication and the two meds end up having a conflict and the patient's blood pressure drops, again, I have failed to meet the standard of care because I am expected to ensure that the patient does not have any contraindications to a medication or a procedure prior to doing so. So as a quick recap, scope of practice is everything that you can do, and the standard of care is the bare minimum you must do. And this just kind of visualizes it. So a basic layperson civilian with no training really has no minimum that they're expected to do because they have no obligation to do anything at all. We do have what's called a duty to act, and we'll talk about that in a second. But since we have a duty to act, we are obligated to perform, and when we perform, we must perform to that minimum. And in this case, we term that as the standard of care. We cannot operate above or outside of, though, our scope of practice. We cannot perform a task or administer a medication that we are not otherwise trained and authorized and permitted to do. This section is muy importante. That is the Spanglish that you will get out of me. It's about as much Spanish as I speak. But what we want to do here is understand the principles of consent and refusal. Failure to do this could result in charges against us of assault or battery. So consent means that the patient has to give us express consent to actually treat them. Now, there are some ways to work around that, which we'll get to, but generally speaking, for the vast majority of our patients, we want to receive expressed consent, meaning that the patient explicitly says, yes, Scott, you may perform this task, you may administer this medication, you may in fact transport me to the hospital. And the important thing when getting express consent is that they have to be informed. If I simply walk up to a patient and I say, hi, my name is Scott, I'm a paramedic, and I'm going to take good care of you today. And from there, I proceed to start an IV, administer a bunch of medications, and do a bunch of other stuff. I really haven't received expressed consent because I didn't inform the patient of what's going on. So when I try to just get a blanket consent, that works to an extent, but really I need to inform the patient of everything I'm doing as I do it. So, hi, my name is Scott. I'm a paramedic. We're going to start out. I want to get a set of vital signs, take a blood pressure, pulse, that type of stuff. From there, then, I'd like to go ahead and start an IV, and I'd like to administer this medication. The reason I'd like to administer it is because it's going to do this, that, and the next thing. I want to be sure that I'm fully informing the patient of what I intend to do, the associated risks and benefits, and then I get their consent to do so upon informing them of everything. Now, what happens when a patient can't understand us? What happens when a patient can't give express consent? Well, then we can operate under implied consent. And implied consent pretty much says that under normal circumstances, most people would want to receive care or treatment, along a certain line. So, a child, for instance, a child under the age of 18 cannot legally offer consent. So if I were to go to go to the playground, right? We're called to the playground for a kid who maybe broke their arm. Mom and dad aren't there. They can't give us consent. The child is under the age of 18, so the child can't give consent. I can operate under what's called implied consent. I can ensure that the patient is provided with a reasonable amount of care and that the mom and dad, under normal circumstances, would want their child to be cared for appropriately. The same thing can apply for people who are incapacitated. So we have the mentally handicapped population. They're unable to comprehend the risks, the benefits, and therefore they're unable to provide express consent. So we can operate under implied consent. Now, there's always limitations. Simply having implied consent doesn't mean we can do whatever we want, whenever we want. In the instance of the kid with a broken arm, I have to really think about it. Do those parents want their child to receive narcotic pain medications? Maybe, maybe not. I know for myself as a parent, I would be hesitant for my child to receive narcotics unless they're in extreme discomfort or pain and there was no other option. But I would much rather that we try to treat it with psychological first aid, trying to calm the kid down, maybe administer an ice pack or two, a nice soft pill splint. These are all things that I would prefer as a parent. So I really do have limitations, and I have to exercise good judgment here. What would the parent want? What's appropriate? What's going overboard? And in the instance of the mentally handicapped patient, depending on how profound their handicap is, you know, they may be able to tell you yes and no. And although they're not able to answer questions appropriately and they're not necessarily considered decisional, if they're obviously against something, if something scares them, makes them uncomfortable, if they don't want it, unless it's going to be detrimental to them not to perform a task or procedure, you can go ahead and respect their wishes. So again, respect the wishes of the patient to the extent possible, so long as it's not going to cause any type of long-term harm. Some other ideas or uses for implied consent may be under the influence of alcohol or drugs. And we also, to an extent, utilize complied consent with suicidal patients. And we'll talk more about those patients in the behavioral chapters. So children and mentally incompetent, we just kind of hit on this. Consider this though. So a 2-year-old child that is with grandma and grandpa, mom and dad aren't around, mom and dad are legal guardians. Yes, we can treat under implied consent. However, what about a 17-year-old? And think back to when you guys were 17. At that point, you're competent, you're an adult for all practical purposes, and you should be able to make most decisions on your own. However, the law says since you're not 18, you can't. Well, think about that. Think about how you would feel at the age of 17 if somebody stripped you of your independence and your decision-making ability. Although, yes, the law is on your side, you should really kind of talk to the patient and try to operate within the confines of their wishes or consent. Um, what happens if a 17-year-old, mom and dad aren't around, 17-year-old gets into a bad car accident and they are in excruciating pain? Going back to the narcotic thing, if you say, I'd like to administer fentanyl for pain, and they say, no, no, I don't want fentanyl. Well, then in that case, I would certainly listen to them. Where it kind of becomes dicey is where, mom and dad want their son or daughter evaluated, transported, whatever, and the 17-year-old says, no, I don't want to be evaluated. No, I don't want to go to the hospital. In those situations, since they're under the age of 18, mom and dad do have the final decision, and we would have to respect mom and dad's wishes. We also have what's called in loco parentis, and what that is in lieu of the parent. So most schools require the parents to sign documentation along these lines, meaning that if the child is on a school bus on the way to school, from school, or any activities during school, including extracurricular activities after school, in all those situations, school officials have limited ability to act on behalf of the student. So if a student is injured at school and an ambulance is called, the principal or other school official will have limited capacity to authorize treatment and transport on behalf of that student. We still need to take appropriate measures, though, to try to reach mom or dad by cell phone, explain to them what's going on, and receive expressed consent from mom or dad on the treatment of their child. Emancipated minors, it's not something we run into all too often, but it certainly could happen. Emancipated means that they have essentially legally divorced their parents before the age of 18. So they went through a court system, they petitioned the courts to allow them to become separate of their parents, independent of their parents, and they now care for themselves. It does not happen often, but it does from time to time. Typically, those patients will carry some type of paperwork proving that they are emancipated. But what happens when we come across a student or a child for that matter, let's say at the age of 17, who says that they are emancipated, that they can make their own decisions on their own behalf, but they don't have any paperwork to prove it? In that situation, and in all situations where we're just kind of unsure of what the appropriate course of action would be, we should reach out to medical control. Call the hospital up, explain to them the situation, and kind of let them offer you some guidance on how they want that handled. So I think we've kind of gone on, we've talked about that stuff. Minors serving in armed forces. I know that this is always kind of a topic of conversation. Per my understanding, though, there are almost no situations where a minor would be admitted into the military at this point in time. I do believe that there are some rare exceptions, but generally speaking, that should not apply in many circumstances at all. Let's see. So what about adult patients incapable of informed decisions about care? Going back to the mentally incompetent, that addresses that. But what happens now if they're under the influence or something else? Those patients do not have the ability to refuse care, and we are obligated to provide care and transport to them. So that brings us to the involuntary transportation. Now, this, folks, is something that we do all the time, and it is very, very dicey because if done incorrectly, it amounts to kidnapping. And that's not exactly anything that we want to be trying to defend ourselves for in court. So, when can we and can we not transport somebody against their will? A mentally competent patient, meaning that they're alert, they're oriented, they're answering questions appropriately, they understand the risks of their decisions, and therefore they are deemed to be decisional. Those people, they can refuse care even if it means death. So if I get shot, and we just had this last week at Woodstock, an individual was stabbed in the abdomen and refused care. It was an actively bleeding stab wound, and the risks were explained to this individual. Listen, if you don't go to the hospital, you could bleed out, you could die. This is bad. You need to go get checked out. The patient refused. They were able to answer all questions appropriately. They knew who they were, where they were, what was going on. They were able to engage in a normal conversation. Everything about them said that they are competent and they are decisional to make their own decisions. So they called the hospital. The individual signed some refusal paperwork, and the ambulance left. Now, coincidentally, they checked themselves into the hospital a few hours later, but nonetheless, that patient was decisional. They were competent. They were informed of all the risks. Therefore, even though their decision could lead to death, they were allowed to sign off. What about though? My wife calls up and says, my husband is making suicidal statements, or my husband is under the influence of alcohol, is unable to take care of himself, and is threatening to harm me. In those situations, we do have the ability to transport against the patient's will, and it gets to be very difficult. If a patient, even if they're alert and oriented, right? So the cops show up, the ambulance shows up to my house, they're talking to me, I'm alert, I'm oriented ×4, I'm otherwise decisional, but my wife says he made a suicidal statement and I'm willing to sign paperwork to attest to it. Well, if I made a suicidal or homicidal statement, whether I'm competent and decisional or not, I forfeited my rights to refuse care. So we are obligated, we are mandated to transport all suicidal and or homicidal patients to the ER for evaluation. We cannot allow them to refuse care. It's outside of our hands, or outside of our control, rather. So in those situations, we actually have an involuntary petition. It is a legal court order. We'll fill it out at the hospital. If I personally hear a patient make a suicidal statement, then I can fill it out. If in the example I used, my wife heard me make a statement and she's willing to sign, she has to be the one to go to the hospital, fill out the form and sign it. A police officer can fill it out and sign it. It all just depends. Whoever heard or experienced the comments firsthand, those are the ones that would have to sign this petition. What ends up happening is we fill it out, we sign it. It actually goes before a judge, and as long as it's filled out correctly and the hospital has it available, it's good for a mandatory 24-hour hold against the patient's will. And during that 24 hours, they will be evaluated by crisis. And if crisis deems that they are a threat to themselves or others, they can petition to have the patient committed for an even longer period of time. When a patient refuses care, the important things are that they are fully informed of all the risks. I had one of the most stubborn old women I've ever met in my life years back. She calls us for chest pain. I'm sorry, let me correct that. Her daughter called us for chest pain, saying that her mom was experiencing pain. So we got there, we did the assessment, did the EKG. EKG says that it's a STEMI. This woman is having an active heart attack. So we start getting the cot ready, getting everything prepped, and she says, "What are you doing?" I said, "Well, we're going to get you onto the cot to get you up to the hospital. You're having a heart attack." "Well, I don't want to go to the hospital." And I said, "Ma'am, you're having a heart attack. We got to get you up to the hospital right away. This is time sensitive." She says, "Nope, I'm not going to the hospital." And I was just dumbfounded. So I went over the questions, who you are, where you are, blah blah blah, made sure she was competent. And I said, "You understand that if you don't go to the hospital, you're probably gonna die, right?" And she says, "I'm willing to risk it." This was, I think, a Thursday, and her grandson or granddaughter was scheduled to graduate high school on that Saturday, and she was not going to miss that graduation for anything. So, I mean, this was really concerning to me because I knew that this patient was going to likely die if we didn't transport her. So I called the hospital up and I said, "Listen, this lady is having a STEMI. She's adamantly refusing to go to the hospital. I don't know what else to do. I've explained all the risks to her. She's signed the paperwork saying that she understands the risks." So the hospital got on the phone, the doctor, and the doctor talks to her and said, "Ma'am, you're gonna die. This you have to get this treated." And she refused. And I bet we spent a better part of an hour arguing with her before we finally left. And she refused the transport, signed the appropriate paperwork, and off we went. We were done. Now, several hours later, they ended up calling back, and again, she was transported. So the moral of the story is everybody who refuses care usually ends up going in anyway. But nonetheless, we have to be very, very diligent in making sure that the patient is fully informed of the risks, that we document all of the risks, and that we have the patient sign the paperwork acknowledging all of the risks. Those are the ways that we're going to absolve ourselves from the liability. So I already kind of gave you an example there of trying to persuade the patient to accept the care and transport. Sometimes we really got to work on them, but eventually they will probably give in because they'll understand the inherent benefit to the additional transport. Let's see. Good, good, good. So what happens when a patient refuses care? They're allowed to do so. They're considered competent. They are decisional, and we do something anyway. Well, that's when we run into assault and battery. If a patient says, "No, I don't want to be transported," and I come back and I say, "If you don't voluntarily go, I'm going to tie you down and we're going to take you anyway." If I don't have the legal right to restrain the patient and transport them against their will, by making that verbal threat, I just committed assault. So assault is a verbal threat to do something that you are not otherwise authorized or legally permitted to do. If I actually put hands on my patient, if I touch my patient, I try to restrain them, I try to put them on the cot, I try to take them against their will, the physical touch itself, that's the battery. So assault is a verbal threat, whereas battery is the physical contact of actually doing something against the patient's will. In the situation where a patient is refusing care and there's a inherent risk to them doing so, it's advisable that you have a witness sign it. A police officer could be one of the witnesses, but in a perfect world, it's a family member or friend, a non-biased party that it would be willing to sign and acknowledge it. There we go. So some other legal documents that we're going to run into: DNR, or in what is now called a POLST form. So many of you have probably heard of a DNR, a do not resuscitate order. Those things are actually fallen kind of by the wayside. You'll still see some from time to time, especially some older forms. But as of a few years ago, we switched over to what's called a POLST form, Physician Order for Life-Sustaining Treatment. And what that does is it's a DNR for all practical purposes, but it's far more explicit. It says specifically, "Thou shall do this, thou may not do this," etc. So maybe it's, "Do not do CPR, but provide me with ALS medications to make me comfortable." or maybe it's, do not do CPR, but you may put me, if I go into a coma, you may put me on a feeding tube, or don't put me on a feeding tube. I don't want to be on life support, those things. It allows the patient to really kind of customize what type of treatment and care they will or will not receive once they become incapacitated and they're not able to make decisions on their own. All right, other legal issues. Negligence. So this is a big one. There are 4 components required to prove negligence. And unfortunately, in the state of Illinois, a couple years ago, because of a court ruling, it just became easier to prove negligence. So in order to prove that an EMT or an EMS provider in general was negligent, we must first of all prove that they had a duty to act. So what is a duty to act? A duty to act means that you are legally obligated to provide care. You are legally obligated to meet that standard of care. So anytime you're on duty or in uniform, you can reasonably assume that you have a duty to act. If you're on shift, the tones drop and your vehicle is due to respond, without a doubt, you have a duty to act. If you show up ill-prepared, your equipment is non-functioning, you don't have the appropriate supplies, or you just didn't take the time to review a new protocol, or maybe you just do a piss poor assessment. In any of those circumstances, you had a duty to act and you failed to meet that standard of care. So whenever you fail to meet the standard of care, you've therefore breached your duty. A patient is in cardiac arrest. I show up, I perform an assessment, and I realize that they need to have CPR done. I've acted, right? I had a duty to act, there's no doubt about it. However, in doing CPR, I do a compression to ventilation ratio of 10 to 1. We know that for CPR, we should be doing 30 compressions to 2 ventilations, but for whatever reason, I screw up and I do 10 to 1. I clearly did not meet the standard of care. So therefore, since I didn't meet the standard of care, I've breached my duty to act. So once a breach has occurred, now we have to look at damages and whether or not that causation occurs between the damages and the breach. So as a result of my breach of duty, did the patient receive damages? Yes or no? And that's going to be argued in court. And that's going to come down to who's got the better attorney. They have to be able to prove that A, the patient was in fact harmed, and B, that the harm that the patient experienced was directly a result of my breach of duty. So there was an example of, I forget where it was, but a case study years back where a patient was in cardiac arrest, and for whatever reason, the EMS crew did not perform CPR. So there was a lawsuit filed, and the lawsuit claimed negligence. And the damages were claimed that the patient was deceased. So obviously the patient experienced damages. Unfortunately, though, the debate was, well, the patient was deceased when EMS got there. So the actions of EMS, their failure to perform CPR, did not actually cause the damage. It did not cause the patient to go into cardiac arrest. The patient went into cardiac arrest long before EMS arrived. However, the failure of EMS to initiate CPR, to start those compressions, did deprive the patient of the potential to come out of cardiac arrest, right? The potential to live. So that case was argued back and forth. And I'll be honest, I don't know what the final outcome was. But in that situation, do you really want to be arguing that, yes, you screwed up, but it shouldn't be your problem because, well, there was something wrong already? It's not a situation you want to be in. So to wrap that up, in order to be guilty of negligence, you must first have a duty to act. You must then breach that duty. There have to be damages, and you have to be able to prove or link that the damages are caused directly by your breach of duty. If those 4 things can be proven, then you can be held liable for negligence. What could that lead to for you? License suspension or revocation. personal lawsuits, civil lawsuits, criminal acts, all sorts of things. So it's bad, to say the least. I'm not going to worry about this. Nobody can even pronounce it, so why even talk about it? Again, a little bit more into duty to act. There was a case study from New York City. A New York EMT and a New York dispatcher, boyfriend, girlfriend, they met during their assigned break at a coffee shop. As they were sitting at the coffee shop talking, again, they were working, they were in uniform, but they were technically on break. Somebody came from the coffee shop and said, hey, one of the employees is in the back, they're not feeling well, can you come help? Now, these employees were off duty. They had no equipment, they had no anything, but they were in uniform, clearly identified who they were and what they did, what their level of training was. And they said, well, we'll call 911, but we're not going to go back there. So they called for an ambulance, had an ambulance dispatched over there, but they did not go into the back of the restaurant and provide any level of care. Assessment, no nothing. And the patient ended up dying as a result. Now, again, did the patient die because the EMT and dispatcher failed to act? Or, I mean, had they gone back there without any tools or equipment whatsoever, would that have changed the outcome? And that's what came down to the lawsuit. And again, that was argued in court. So, did they have a duty to act? The argument was, well, although yes, they were in uniform, they technically were on their break, so no, there was no duty. And the prosecution argued, yes, there was a duty to act. So that had to be deciphered. From there, then the question is, did they breach their duty? Well, they didn't have any equipment. They didn't really have the ability to do much. So how could they have breached their duty? What could they have done? They called for an ambulance, and that was it. Although we do know that we can go back, we can provide basic assessments, we can provide psychological first aid, try to keep the patient calm, slow their breathing rate down, whatever the case is. And then from there, were there damages? Well, damages obviously was death of the patient, but were those damages caused from a breach of duty? And again, that was a court argument. So interesting cases on those things, all things that obviously we'd want to avoid if at all possible. Abandonment. This one's kind of simple. It says that if you begin to render care to a patient, you have to continue to care for that patient until you have formally transferred care to somebody of equal or higher education. So as an EMT, if you initiate patient care, you could transfer patient care to another EMT. You have to do it face to face, you have to do it at bedside, and the other person has to formally accept responsibility for the patient. For me as a paramedic, if I begin care, I cannot transfer to an EMT. That would be considered a downgrade of service. I can only transfer to another paramedic, or I could transfer to a nurse or a physician. So those are kind of the limitations. Where this could apply is if I, let's see, if I take a patient to the hospital, I move them over onto the hospital bed, and I leave. The nurse never came into the room. I never formally transferred care. I never gave a bedside report, and I just up and left. In those situations, that would be considered abandonment, and I could be open to some pretty substantial legal liabilities for that. Good Samaritan laws cover civilians and covers EMS providers to a certain extent. Each state has its own Good Samaritan law. Illinois' Good Samaritan law is actually pretty good. It's pretty comprehensive. But what it essentially does is it says, listen, as long as you're acting in the best interest of the patient, you're not being an idiot, then you're protected. They have to prove what's called willful and wanton misconduct in order for you to be considered guilty of negligence and violating, Good Samaritan protections. However, the Good Samaritan law does a great job protecting civilians. It has limited coverage when it's applied to EMS providers. Again, we are held to a higher standard. We have higher expectations. So therefore, the Good Samaritan law is only going to do so much for us. All right, confidentiality. I'm sure everybody's heard of HIPAA. I know day one in class we talk about HIPAA extensively. Privacy, privacy, privacy. Confidentiality, confidentiality, confidentiality. We cannot disclose anything about our patients, not about their medical history, past or present, not about anything that we did. To play it safe, you don't talk to anybody unless you have a court order to testify on behalf of that, or unless it's part of your QA/QI team at your fire department. Other than that, you need to maintain the utmost confidentiality of all of your patient information. So the Health Insurance Portability and Accountability Act, or the HIPAA Act, covers all that. And essentially, again, like I said, protect your patient's privacy. That's the big stuff. From time to time, we'll come across medical identification devices. You'll see some different bracelets here. Some people wear necklaces. I've even known a couple people to get tattoos of these things. It was funny though because I was down at a conference in Florida, and the waitress, it was a firefighter conference, so we had shirts on, said who we were, and she was talking to us about how she has this terrible allergy, and the last time she was exposed to this allergen, they had to intubate her, and it was really, really bad. And EMS didn't know about the allergy, so they didn't treat her appropriately. I said, well, okay, how did you expect them to know about it? And she says, well, I have it tattooed right here. And she shows me this little tiny emblem on her wrist. And I said, what in the world is that? And the other guy I was with said, yeah, I've never seen that before. And it was the chemical symbol on the periodic table of elements for the allergen. And she's like, yeah, I read online that as long as I put the chemical symbol on there, the paramedics will see that and they'll know that I'm allergic to it. I said, if there's one thing I'm not good at, it's chemistry. I said, I had no idea what that was. If I saw that, I'd have no idea what you're talking about. And I said, not to mention the fact it's so small and inconspicuous that I probably wouldn't have even looked for it or seen it. But nonetheless, she had it. And that was a learning experience for me that I really need to be paying attention. Now, it's going to be difficult when people are covered in tattoo ink, but just be aware that that stuff does exist. All right, special situations. Organ donors. All you need to know about organ donors is that we will treat them exactly the same as any other patient. That's all. Let's see. Oh, safe haven laws. This is a good one. So every single fire department and every single police department that are staffed on a regular basis are considered a safe haven. And there was an issue a while back where we had a record number of dumpster babies. People were just dropping their babies off in dumpsters because they didn't want them, leaving them, abandoning them, and obviously, the babies wouldn't make it. So they put together this state legislation, and it said that as long as you bring the baby within a certain time to a fire station, police department, or whatever, you can drop them off there. So you may be sitting in the radio room or sitting at the kitchen table at the fire station. The bell rings and you go to open the door, and there could be a mom or a dad there with a baby, and they say, here you go. We don't want our baby. You have to take it. There's some parameters in there. I don't remember all of them myself. I've personally never had this happen before. But there's some paperwork that they have to fill out. What's the baby's name? When were they born? What type of medical treatment have they had so far? And that's it. You have them fill out the paperwork. They sign the paperwork, and they turn around and walk out the door. And you are now playing permanent babysitter until somebody from the state comes and picks that baby up. Crime scenes. So this is kind of important, and this is an area where law enforcement and fire and or EMS can kind of bicker from time to time. If we have somebody that is ill or injured, our priority is always patient care. And while the law enforcement officers are also valuing patient care, they also value the investigative component, right? They want to preserve the crime scene, preserve any clues, because they want to be able to utilize that to identify what happened and prosecute the people that are responsible. And at the end of the day, I think about it with my family. Yes, if my wife, for instance, was ill or injured, I would want her patient or her care to be priority one. But at the same time, I would want whoever caused her harm to be found and prosecuted for it. So what we have to understand is that police will sometimes be hesitant to give us access to a scene if they suspect it was the scene of a crime. When we do get access, we need to be very careful that we don't destroy any types of evidence, and that may be, kicking bullet casings across the ground or moving furniture that had blood splatter on it. It could even be if we have a patient that was stabbed or shot. If I need to remove their clothing, I want to cut well away from the bullet wound or from the hole in the shirt from the bullet or the knife, because all that can be used in ballistic analysis and can be used for prosecution purposes. So these are all things that I want to be very careful of. Clothing, sheets, everything else from a sexual assault, all of that should be preserved. That's all evidence. And we can talk more in class about how to preserve evidence and the chain of evidence, but just understand that we need to be very much aware and able to work with law enforcement to help them do their job just as much as we want them to help us do ours. All right. So some special reporting requirements. We are mandated reporters. Effective right now. You are now considered a mandated reporter. Realistically, if you went through EMR class, you became a mandated reporter then. If you are currently a law enforcement officer, you are already a mandated reporter. Nurses, teachers, law enforcement officers, EMS professionals, firefighters, all of us are trained, and therefore we are mandated reporters. So what that means is that if we are aware of or suspect child abuse, elderly abuse, domestic abuse, violence, sexual assault, any of those situations listed there, we are legally obligated to report it. We have to do so. If we fail to report any one of those situations, we could again be held negligent as a result. Let's see. So, in these situations here, they kind of fall into the parameters in the prior slide, but mentally incompetent people with injuries. So, is it somebody who just simply fell, or do we believe that maybe this person who is mentally incompetent is either A, being abused, or B, is unable to care for themselves and their caretaker is being negligent by not providing food, shelter, water, general supervision, that type of stuff. And that's it. That's chapter 4 in a nutshell. Just under 45 minutes of discussion there. There's so much more to this, so we can get so in depth with it. There are a lot of what if questions, a lot of scenario based questions, and we'll use classroom time to kind of go through those. But you should be at least generally familiar with these terms and their application. Please bring any questions that you have to class with you, and this will be a big topic of discussion in the classroom. So thanks again, and hope you enjoyed, and we'll talk to you later.